For latest updates, subscribe to our channel and press the bell icon.
Hello everyone, my name is Viren Dayal. I'm a custom broker, a trainer and a faculty. The topic which I'm going to talk to you about under the Customs Act is a little different in the sense it does not cover any duties of customs or levy or any clearance process. It's on the criminal side of the Customs Act. The topic which I have chosen to speak on is known as compounding of offences. Since this topic has the word offences, let me first give you a background note on what are offences. Under the Customs Act, two liabilities accrue in case there are any offending goods or are goods which are prohibited in India. Offending goods could be improper importation or improper exportation, and the offending goods are normally liable to confiscation by the custom authorities. Before they are confiscated and the title is passed on to the government, a seizure memo is being done, or rather the goods are first seized, then the show cause notice is given and the adjudication process takes place under section 122 and 122A of the Customs Act. So under the Customs Act, two liabilities arise for any offending goods. One is the civil liability and other is the criminal liability. The civil liability which I just told you about is payment of penalty, fine, redemption fine, duty, interest and so on, which can be settled by the importer or exporter on payment of cash money or by payment of DD, and the goods may be allowed to be released. So this is the civil liability. But if there are certain instances like evasion of duty, goods which are prohibited, if such goods are imported, then it gives rise to criminal liability, and that is more appropriately covered under Chapter 16 of the Customs Act 1962. Chapter 16 talks about offences and prosecution. Chapter 16 of the Customs Act starts with section 132 and ends with section 140. More particularly, section 135 is the harshest one, where there could be evasion of duty and also prohibition. Now the custom authorities are not empowered to carry out criminal prosecution, and therefore the criminal prosecution can only be tried by a sessions judge in a sessions court. Therefore, the criminal interface, besides the civil liability, many a times can accrue at the same time depending upon the severity and the depth of the criminal liability which has taken place. As an example, if there is an evasion of duty of more than 50 lakhs, or there is a misdeclaration of value where the market value of the goods are 1 crore, or there is false declaration, or taking exemption from duty under section 25, or there is section 28 AAA which is clearing the goods on a fraudulent exempt script issued by DGFT and so on. As per Supreme Court, both these liabilities, the civil liability and the criminal liability, can accrue together. Now I will tell you in exactly which topic I have chosen as far as today's video is concerned. The topic I have chosen is compounding of offences and cognizance of offences. The word itself means that the offence has taken place and the accused, the importer or the exporter, may be behind, or the importer and the exporter may be imprisoned. Now under section 137 of the Customs Act, the heading says cognizance of offence. The word cognizance means to take note, to take notice. So what it says that where an offence has been, or rather where an offence has taken place under the provision of section 132, 133, 134, 135, 135A, 135AA, by an importer and exporter, the court will not take any notice, or the court will not take any cognizance, that is the sessions court, till the Principal Commissioner of Customs or Commissioner of Customs tells them to do so. In other words, it is possible that the accused may languish in jail till the charge sheet is not filed by the PC or the CC. These sections mainly pertain to the criminal interface which involves imprisonment. The second point is that sometimes custom officers can also be tried for criminal interface under section 136 of the Customs Act. Now, if the criminal offence has been committed by an officer of customs who is above the rank of an assistant commissioner or deputy commissioner of customs, above the rank means DC, additional commissioner, and so on, the court will not take cognizance or the court will not take any notice until the central government gives directives that you can now start the criminal proceedings. And if a custom officer who is below the rank of an AC or DC, then the court will not take any notice unless and until the PC or the CC gives permission to do so. So this is as far as cognizance of offence is concerned. Now let me give you what is meant by compounding of offences. Compounding offences is under subsection 3 of section 137. And it says that where an accused before or after prosecution wishes to compound his offence, means come to terms, do a settlement with customs so that he can start on a clean slate. In such cases, compounding of offence under section 137 subsection 3 is possible. As per Black's Law Dictionary, compounding means to settle a matter in lieu of imprisonment by paying money to the concerned authorities. So under the Customs Act 1962, the compounding authority is the Principal Chief Commissioner of Customs or the Chief Commissioner of Customs, and this compounding authorities can be approached by the accused either before the institution of the prosecution or even after the prosecution has begun to compound the offences and pay the required money known as the composite money or the composite amount. And depending upon the kind of offence, the Compounding Offences Rules 2005 give the details on the amount of monies to be paid for different kind of offences. Once the compounding authority, that is the Chief Commissioner or the Principal Chief Commissioner, agree for compounding, the accused makes the payment. Then the compounding authority and the accused make a joint representation to the criminal court or the sessions court that since the compounding has been done, the case may please be withdrawn if the prosecution has not started, and if the prosecution has started also, the case may please be withdrawn and the accused may be allowed to be set free. But if the sessions judge in the sessions court feels that the severity of the offence is such that although compounding has been done, he still wishes that the accused must be tried under the criminal prosecution and therefore can direct the compounding authority to return the monies paid by the accused because he wishes to continue the prosecution. This can happen in some cases. That means compounding is not a right. You have to request for compounding, and upon various parameters involved, all various other duties and other payments have been paid or not paid, penalties have been paid or not paid, the compounding may be allowed. So this is what is the procedure for compounding. However, although you are willing to do compounding, that means pay the composite amount, if the case pertains to the Narcotics, Wildlife Protection Act, the Arms Act, SCOMET items, or where the accused has been given compounding once with a value of more than 1 crore, and such are the parameters which are given under section 3 of section 137, then compounding is not permitted. Therefore, importers and exporters should be aware of these provisions, and any import done or export done which is not compliant with the Indian laws can many a times lead to a criminal interface and also lead to imprisonment. So this is what is all about compounding under the Customs Act 1962. I hope you have liked this video too. Thank you.
For detailed learning of all logistics subjects, visit www.logiveda.com.